All right. First, thank you. Cycle. I have my dog here. Oh, my internet's unstable, it says. Hopefully it stables itself out because I rarely get that message. I just want to thank you for being here, and I hope you find this useful. Tonight we are going to talk about essay writing, and we're going to talk about constitutional law, which I know is for most people kind of the scariest topic that can come up, or scariest subject for an essay. And they're hard. They're really, really difficult. So I'm going to walk you through some of the difficulties, and Archie's going to go away. We're really going to talk about, we're going to focus on equal protection tonight, because the skills that I give you to talking, the skills that I give you in equal protection translate to many of the other topics within con law. And also, a lot of you know, I have these essay workshop courses, and I go in a lot more depth in the essay work and those. But it's obviously not, I can't cover everything in a single lecture. So we're going to get digging into con law, and we're going to talk about essays generally. So give me 1 second while I get this going, and we're going to hope Archie cooperates and doesn't freak out that I have neighbors arriving. So if you hear Archie, I apologize, but he's really cute, so there's that. Okay. And Noelle, can you figure out how to drop in the chat? Well, not yet, but in a little bit. We do have an essay that we're going to look at, and we'll drop it in the chat. You don't have to read it in advance. I was going to send it out a little earlier today, but I didn't really want you all to get too in depth into it, because I really want us to have a discussion about it tonight. So the objectives, you're going to understand how bar grade is great, understand how to approach bar essays, and also how to attack equal protection in con law essays. I really want to focus on that. Because really, and the reason I want to do that too is just, there's so many topics on the bar exam, and I want you to know how to think about it. Like when you think of okay, I'm scared of getting Civ Pro essays. Are you really scared about getting Civ Pro essays? Are you really scared about getting con law essays? Or is it one particular part of Civ Pro, one particular part of con law, right? Whenever you're feeling like that, how many of you guys feel that way about just con law generally? Do you feel like that about every single thing in con law? Or do you feel like that about certain things? Like for most people, it's like I don't like commerce clause for whatever reason. I can do commerce clause. I don't like dormant commerce clause. I can do equal protection, all day long. I can do a substantive due process all day long. I don't like procedural due process, right? So I want you to think about, whenever you think about a subject and you don't want to write an essay, I want you to really think about, okay, well, what is it about that essay? And when you're critiquing your essays, don't say I did terribly on that essay. Say, I did these things well, and these things I need to fix. So part of this process of studying for the bar is just, all of it is really uncomfortable. But I want you to think of and we tend to, bar takers tend to be really hard on themselves, generally speaking. And I say hopefully, because I want you to be critical of yourself so that you push yourself to succeed, and not just say wow, I got everything. Because I hear that a bit too, where people come to me, or I meet with them to go over their essays or their PT, and they say, well, I hit all the issues. Why did I only get a 50? I'm like, well, because you're 55 usually. I hear that. So I want you to always, look at your essays with a critical eye. We're going to talk about that tonight too. But whenever you feel like you really did terribly on an essay, I want you to also, whenever you're in that mode, remember to look at the essay and ask yourself what you did well, because I guarantee there are things you did really well, and identify just those things that you need to improve on. And when you break the tasks down that way, it tends to make it a lot easier. So, and that being said, equal protection, you want to think about every single subject, within con law. We'll talk about this a little bit tonight. What are all of the issues that come up in con law? It's not all of con law. It's standing, ripeness, mootness, 11th Amendment, commerce clause, dormant commerce clause, equal protection, substantive due process, procedural due process, freedom of speech. Within freedom of speech, there's various issues. You have to think about, okay, what are the issues, and how do I organize every one of those issues? So I want to give you some structures. I'm going to give you a structure and an approach to anytime you get equal protection, you need to go through this process. And with the essay course, that's what I really like to do is yes, we always will cover some essays. However, we're going to say, all right, well, what happens if I get equal protection? What happens if I get, freedom of speech? What are all of the steps that I need to go through so that you can not just answer one particular COMLA essay well, so that you can answer any essay that tests those particular topics well. That's the goal. That's the goal. So you always want to say like, all right, we did this essay. Now, how can I take this and apply it more broadly? How can I take what we did today and apply it more broadly? So, all right, let's get into just some quick things, some, a little review. And if those of you came to, I don't know if all of you have been to my workshops before, but I did one a couple of weeks ago. I think it was a couple of weeks ago now, where we reviewed the February 22 bar essays and PT. I also did an MBE workshop that was free, and I did a PT workshop. All of our workshops, including tonight's and including the handouts and the PowerPoint, all of our everything that we do is posted. We have on my website, bar-md.com. We have a course called Free Workshops. That's where like all of these things I do for free that are recorded and all of the handouts, everything gets posted there within 2 days. So you'll be able to find everything right there. So just so you all know that it's there. I have past ones that I've done, PT workshops, like all sorts of stuff that I think is helpful. It's all there. So, all right. I'm making sure my dog's not getting into trouble, making sure that, yeah, Michael. Yeah. Noelle, can you put the link in the chat, please, for where they can register for those? Yeah, it's on the Bar MD. Thanks, Michael. All right. So just a quick review. This is something I mentioned if you did come to my workshop last week, but bar graders, one thing I want you to always think of is, and not that this is true, not that it's necessarily true, but at least I am when I'm in this position, not as a bar grader, but just grading generally. Bar graders are grumpy. But your bar grader, you want to assume that your bar grader is not in a good mood and they're reading your work, right? Don't you want your bar grader to be in a good mood when they're reading your work? Because you want them to be generous with the points. Part of your job is to put them in a good mood. Make it really, really easy for them to give you the points. So you have to organize incredibly well, because if you organize incredibly well, then it's really easy for them to see that you spotted the right issues, and they can see your analysis and they can see that it's correct. So we really, really like that. We really like it. Or bar graders do. I've never been a bar grader. I'm not allowed to be, given that I own an exam prep company, Bar MD. So bar graders are grumpy and they're spending 2 minutes looking at what you wrote, right? And we know this because of a lot of things. We have actually heard this. I've had colleagues. I am a professor at a law school, and I've been at several law schools, and my colleagues have been to what are called calibration sessions. That's where the bar graders get together and they talk about the essay. So for those of you that don't know, the way that bar graders, the way that the grading is done, and if you guys want more detail, I can talk about it at the end. I'm just going to give you some basics. It's like, so you have 6 written assignments, right? You have 6 written events is what they're referred to as events. So 5 essays, 1 PT. You have a different grader for each written event. Because of that, so that means that like for a July bar, there's going to be like 10, 15 people that are all responsible for grading one single essay. And they each get like a banker's box full of a few hundred essays or however many, because there's like 10,000 people to take it. So you have to split those up, whatever. And then, there's, let's say 10 people that are grading a particular essay. At first, all those people are given an essay, they're given the fact pattern, and they're told to, okay, we give this to you, you get the day. You research everything, you figure out how would you answer this, blah, 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 and you write an answer. I think they get like 8 hours to do it generally, if my recollection is correct. They have to figure it all out. They write an answer. So they figure out all the issues. Then they all get together and they talk about what all the issues were. And they figure out, well, what should you get points for? What was required? What was, et cetera. So they figure all that stuff out. So these bar graders know the essay inside and out, which is why they can actually grade them really quickly and be precise for the most part. There are always outliers, but they generally can be precise. Then the bar graders go through a couple of sessions. They go through a couple of rounds of calibration. That's what law school faculty are invited to. So they go through these calibration sessions where they get together and they talk about each one is given like 10 essays to grade, and everybody's given the same essays to grade, and they assign numerical grades, 50, 55, 60, etc. And then they have discussions about the grades. They look at like, all right, well, we think a 55 hit all of these issues. We think of a 60, hit this additional issue or two. At 65, hit these counter arguments, use these facts, etc. And it's not that you get like a point for this, a point for that, a point for that. It is not like that, like how sometimes law schools do that. It's basically they're like my torts professor in law school. If any of you went to USD, my torts professor in law school, he's like, like I remember I will never forget picking up my torts essay, and the whole grade was based on the final exam, and I think I got like a B+ or something. It's like, it looked like a B+. Not a single notation on it, not a single note on it. I was just like what, and it was insane. And that's how bar graders are. It's like, all right, this looked like it was pretty good in comparison to everything else. This looks like it was really good in comparison to everything else. This looks like it was perfect. This looked like it was not so good. They do a holistic grade. So looking at it on the whole, they're not allocating, you don't get 3 points for this and 2 points for this and 2 points for this. So that's kind of how, that's sort of a bit about how that process works. They spend 2 to 3 minutes on the essay because they know that essay really well. They don't dig into your material to find whether you've done it correctly. They look for keywords. They look for thorough analysis. When you, like, I saw somebody's essay today, it was organized beautifully from the February bar, but it was purely, it was almost purely just, there wasn't really any analysis there. It was a lot of stating a fact, stating a fact, stating a fact, stating a fact, and then a conclusion. That is not analysis. So while it looked beautiful, it looked really nice, I could very quickly in 2 minutes see this is, you hit the right issues, but there's no analysis. You're not going to get higher than a 50. So you did get some points for hitting the issues and knowing that those were the right facts to use, but there was no analysis. You're not getting a high score. And so that person didn't understand totally why they had gotten that score, but I can see it very quickly because I know how to connect the facts to the law, all of that. So they look for keywords, they look for thorough analysis, and having a well-organized essay is a baseline. That is just like the bare minimum. So you've got to have that thorough analysis, the right issues, etc. They don't look twice unless you get a second grade, and you don't want to get a second grade because then they look really closely and they really see all the flaws. So they don't look twice. You've got to make it all very easy for them to give you the points. So make your grader a happy grader, make your grader a happy grader, and make them a happy from the beginning. Don't just like spaghetti well and throw tons of irrelevant stuff. So here's some really common mistakes. Here's some really common errors. This is literally a list from, this is from the NCBE, who they're the ones that do, like they do the UBE, but this is the same. Like we know that this is the same in California and the UBE based on comments and all of this stuff. So, but this came directly from a presentation from a little while ago. So these are the errors that they see. And so when you are trying to understand what happened, when you took a bar, if you've taken it previously, or if you're doing it before, when you're self-assessing, you want to look to see if you made any of these errors. And I'll talk about a few of them. So one, make sure you answer the call to question. I see people missing this a lot in civil procedure. They'll go through a whole PJ analysis, do this whole discussion, but they won't answer whether the court ruled correctly. That's not a big deal, but it's still an issue. Failing to use the specific facts. 2 points on this. One, you have to use every single fact in the fact pattern to get a passing answer. You have to use every single fact in the fact pattern to get above a 60. So you have to do that. You also have to use the facts as they are written. Don't just summarize them. They write the facts in a very specific way for them to use them that way. So do it. So you don't have to paraphrase. Don't paraphrase, I should say. 3, lack of organization. If you have massive blocks of text, if you don't label your headings, if you organize it incorrectly, like I had a conversation with somebody today who did their nuisance analysis totally just totally incorrectly. And it looked like they didn't have an understanding of nuisance, even though I actually know that they really did. So lack of organization, not IRACing, stuff like that. That's pretty straightforward. So this says avoid spaghetti walling. You need to not spaghetti wall. An error is spaghetti walling. So that's when I say that, and some of y'all know that you do this, and sometimes it's like, oh my God, I saw that essay and I didn't know what to do, so I just started throwing everything at it. It's like throwing everything against the wall to see what sticks. Don't do that. Don't do that. Or if you're not sure, I saw this a lot with BA on the February bar. Failing to tackle the tough issues. Sometimes people think that like, and the way that I see this come up is often people will see an essay and they'll be like, oh my God, that looks so hard. I don't want to do it. So they've already like on the bar, they've already assumed that they're going to fail, which is not a good place to be. But also like, if there's a big ambiguity, you have to deal with it. They're looking for that. So if there's controversy, if you keep going like back and forth on an issue, you're like, oh, well, it could be this and it could be this. And like, oh, I don't know. That means you have to make an argument for both sides. And usually your conclusion doesn't matter. Also just poor writing. This doesn't come up that much. This really doesn't come up that much, but it is something that is seen enough that it is mentionable. I see that fairly rarely, to be honest. Like I've met with hundreds of people over the last few weeks since bar results came out. And I that's rare that I actually see that an essay is written so poorly that I can't understand it or like understand what they were trying to say. Number 7, this happens a lot where people are just restating portions of the fact pattern without connecting the facts to the law. The bar graders, they know the facts. They need to see that you understand the legal significance of the facts. So I see that a lot. That is probably this, and what that really means that there is a lack of analysis. That is probably the biggest reason. That and failing to hit the issues are the biggest reasons that I see people not pass the written portion. Failing to show your work, that's conclusory analysis. Failing to set forth assumptions. So say you think an argument is going to go one way, but it could go 2 ways. If you say, okay, if it goes, if A is true, or let me just do an example. Let's just say like in a negligence question, if you say that a duty wasn't owed, if you conclude that, then you don't go on to whether there was a breach or causation or damages. But the problem with that is if you say no duty was owed, then that stops your conclusion, or that your essay stops there. But you need to keep going. So you keep going and you say, assuming the court found that there was a duty, and then you keep going. So you need to do that. Or sometimes you have to, it's usually doing something like that. That's a very simple example just to keep it easy, but yeah. 10, failing to try even if you have no clue. This is actually the number one mistake I see people make in bar prep, not on the bar, in bar prep. By that, I mean, you are not writing essays closed note and you are not doing it timed. You have to do your essays closed note and timed. You have to do your essays closed note and timed from the beginning. And if you're scared to do that, how many of you does that freak you out? Can you guys tell me, like, click raise hand? Does that freak you out? I feel like I should see every single person's hand go up right now. Yeah, I know, Michael. Michael, I know you, right? I know it should be every single person here. I don't even like to do it. I don't like to do it. And I've written like hundreds of answers. I don't like to do it. I don't think I can raise hand. But the point is that you have to do it, because that is how, yes, I did. You really have to try. You have to identify where are your gaps in knowledge. So if you're scared to do it because you think you don't know, you do know stuff. And you have to identify what you know, and you have to identify what you don't know. You have to identify that stuff, and that's where all the improvement comes. That's where all the improvement comes. And then failing to be professional. This was rare, but like, don't be cute on the bar. Don't joke around or be silly. Like one of my best friends, she passed, but she ended one of her PTs when we had 2. She ended her PTs with like a cute little rhyme. And I was just like, that is so risky, but she thought the bar grader would like it. So anyways, okay, now let's get into some writing essays. So these are the steps you take for every single essay, every single subject, every single essay. This is what you do. First thing you do is 7 steps. First thing you do is you check the call to question. This is pretty broadly out there. Like, I don't stray from this approach, but I will tell you I will show you what this looks like step by step by step. This is what I do in essays. So I will show you what this looks like, and I will show you how to figure out the second step and the fourth step. So check the call to question. Once you know what subject you're in, you have to jot down your entire issue checklist. It should be something that you can write down in like 10 seconds. It's really, really easy. So like for mine, for all of torts, it's got to need to pass this dang stupid exam, GINDPSE or SPE. So I just write down my mnemonic, which tells me every single major category of issues for torts. And I have that. We have, lists of like, what are the issue checklists for every single subject. We have all of that stuff. So check the call of the question, and then you jot down your issue checklist for that subject or subjects. The reason you have to do this, is because if you don't do it, you are likely going to miss issues. You're going to miss issues, and that obviously is a problem. Then you're going to go through and you're going to read the fact pattern. So you don't just start off by reading the fact pattern. You look at the call to question, identify what subject you're in, jot down your issue checklist for that subject or subjects. Then you actually go through and you read the fact pattern and read it carefully. And you're reading it and you're doing it on paper. By the way, all of the essays that you do, you should be doing them on hard copy on paper. Practice this how you're going to do it, because it really makes a difference. You have to get like so used to writing essays that you're just are like good to go. That like bar exam day comes and it's just like, all right, this is really just another day, except today it really matters. And it's maybe a little bit more stress. So yeah, read the fact pattern. At the end, you want to identify, after you're done reading the fact pattern, you want to list all of the issues that are actually tested. So you want to run through your issue checklist and identify all of the issues that are actually being tested in that particular essay. So you compare when you make your issue checklist, you of the actual issues that are tested, and you jot it down. Somebody asked me, I don't know who it is, it says iPhone, how many times you should read the fact pattern. Often you will read it twice. I usually will read it once just to get like a general sense, and then read it twice, identify all of the issues that are tested, and you're going to type that into your exam answer. You're going to type that into your exam answer. You're going to put in all your headings and your subheadings. So let me just go back. Check the call to question. You're going to jot down your issue checklist for the subject. If you're taking my essay course, if you're already signed up for it, it starts next Wednesday. Or if you're in my courses, you're going to jot down, I give you your issue checklist for every subject. So you jot that down. So you'll have that. You go through the fact pattern. You go through the fact pattern to identify all of the issues that are tested. So, if I have here, if it's con law, it's, might be standing, maybe an 11th Amendment issue. And then I see there's a 13th Amendment issue. I see equal protection, substantive due process, procedural due process, etc. So I list out all of my issues and I type that into my exam answer. I actually type it like into ExamSoft. Then I go back and I reread the fact pattern and I'm matching up the facts. I'm saying, okay, I'm using this fact for this issue, this fact for this issue, this fact for this issue. The reason it's important to actually go through the facts and match them, the reason you want to go through the facts and actually match them is because it will help you to triage. It will help you to identify where the points are, which is a tough thing to do. That is a skill that comes by doing tons and tons of practice. People always ask me, one of the questions I always ask people when I'm talking with them, if they've gotten, bad news from the bar exam, like from February, I'm like, how many essays did you write for each subject? People in my full courses write close to 100 essays in full, closed note timed. At a minimum, you're doing 5 full essays in every single subject and issue spotting a bunch more in each subject. So you want to get exposure to fact patterns and lots of practice writing all of the topics that come up, especially all the big topics, but within those, you'll come across all of the smaller ones too that generally come up. We want you to write, get used to like, how do I organize all of these various things? What does this look like in an essay? What facts trigger it? So you match the facts, you triage, and then after you do that, you write. This process, steps 1 through 6, they should be numbered, but sorry, you guys can count to 7. But steps 1 through 6 takes about 15 minutes, maybe 20 minutes. It And that's okay. Even if it takes you 20 minutes, you have 40 minutes left. The point is through this process to get all your thinking done, to get your thinking through the fact pattern done. That's the point. So sometimes people get freaked out. They don't want to do this because they're like, oh my God, time is going, and I need to start typing and all of that. I understand that. However, when you just start typing and you start going and you go like full on and you do this like really great standing analysis, when standing's not even a big issue at all, standing is not in controversy, you need to do it because it's a preliminary issue. But if it's not in controversy and you spent, 10 minutes on standing and then you run out of time on procedural due process and substantive due process, you're not passing that essay. You have to identify where the points are. And so if you just get in, you're like, great, I have my standing done. And now you're like, oh my gosh, I only have 20 minutes left and I've got all of these issues to get through. You have all of those issues to get through. Catalina, did you have a question? You just keep getting unmuted.
No, sorry, I just have some issues with the volume. Sorry.
Oh, no, that's okay. That's okay. I just wanted to make sure that I wasn't like cutting you off. What was I saying? Oh, so when you go and you do that, if you don't follow this process, you tend to lose time thinking and you're just not aware of it. Time is just going. So I just like plead with you all to follow this process and get used to it. And you will find that you are writing longer answers. When I at a law school that I've worked at, some of you may have been my students then. I've had people in this class. I don't think anybody anymore because it was a while ago. But I used to give them the fact pattern. I used to make them outline the whole answer, match the facts, do this. I would give them 20 minutes to do it. And then I would literally take away the fact pattern from them and I wouldn't let them look at it anymore. Then they would have 40 minutes, but they'd done all of their thinking. They didn't have to go digging through the fact pattern anymore. They had thought everything through and all of the facts were matched out of their issues. They wrote better answers. That way. So I do know that if you follow this process, it works. So, and I've put like groups of 40 people to the test and it works. So I do urge you to at least try it. Okay. Now let's talk about issue checklist. This is what like an issue checklist may look like. And I'm going to show you it a bit more detailed as well. But for con law, this is one way you can do it. Now I do give you issue checklists that are pretty detailed. And the whole idea is that you can broaden them, you can adapt them, you can shorten them, etc. But there's really 4 major topics within con law. So the preliminary issues like standing, ripeness, mootness, state action, that's pretty simple. That is pretty simple. Then we also have, can they do that, right? Do they have the power? So you're looking at the various branches of the government, so like the executive power, executive branch, Congress. The big thing that comes up there is Commerce Clause, where the federal government's actually acting. And then, so Commerce Clause, sometimes taxing and spending. And I think it was in 2008. I think it was in 2008 where there was an executive power question and you had to apply the Youngstown sheet case. Judiciary, can the judiciary do that? And then also when it's state action, is there a 10th Amendment violation? Carla asked, is that a good practice, the 20 minutes besides writing full essays? Absolutely, but not in lieu of. So I generally have people write full essays until they've done at least 5 or 6 full essays in a subject, and it's a good subject of theirs. Like if you're not a fan of con law, you're writing more con law essays in full. I'm not a fan of contracts essays, so I had to do more contracts essays until I felt somewhat comfortable with it. I had to feel somewhat comfortable with it. So if it's a subject that you tend to be really good at and you crush the essays, you do hit the issues, your analysis is solid, you're using every single fact, and you've covered the breadth of topics that are tested within that subject, then you can go on to do the issue spotting, doing this practice where you're going through the 20-minute process. I call that issue spotting practice. It's more than just issue spotting, it's issue spotting, triaging, etc. It's really going through a full process. My hair is itching my face. So can they do that? And then have they violated another person's rights or another entity's rights? So like you think about the state encroaching the federal government. So preemption issues, dormant commerce clause, privileges and immunities, contracts clause. is the federal government encroaching on the states' rights, right? So commandeering, right? Commandeering, stuff like that. The big issue, though, is the government violating individual rights, the government violating individual rights. And within that, the major issues are First Amendment, right? Freedom of speech, freedom of religion, which includes exercise clause and free exercise. Due process clause, so both substantive and procedural. Equal protection clause, and takings. Those are really the big ones. Tonight, we're going to focus on equal protection clause. We're going to focus on equal protection. Okay. Now, Noelle, did you figure out how to get that essay into the chat? Okay, Noelle's going to post a file into the fact. She's going to post a file into the chat, not the fact, into the chat. And I'm also going to share screen, obviously. I'm going to share a screen and I'm going to switch over. And I'm not going to go into all the nitty-gritty of this particular essay. I'm going to really focus on the equal protection because I wanted to show you these skills and then, and then I'll answer questions, etc. All right, Noelle just posted that file. You guys should be able to open that up and read it along or read along. Actually, let me give you all just like, I want to give you all, just try this really quickly. You know, you're in con law, but I want you to, let's do this. New share. This and that. Okay. And just as a note, like I said earlier, this handout, the PowerPoint, the essay, all of this will be available in our free course workshops. The video will be posted to YouTube, and there's tons of workshops. I think there's like 5 PT workshops that are in there, which is a little crazy. I'm just giving them away. There's an MBE workshop. There's a bunch of stuff. There's another essay workshop. If you don't like PR, there's an essay workshop on PR as well. That's in there from a couple years ago. That is focused on how to do it without hard copy, but all of the skills, everything still transfers. It's just that now you actually have a hard copy. All right, so we have this particular question here. We have this particular question. What arguments could Pete or his parents reasonably make in support of their action, and how should the court rule on each? This doesn't really give us any information, but I see directly above it that it lists that there are some numbered things. So that's really probably the questions. So they say the 13th Amendment's involuntary servitude clause, the 14th Amendment's due process clause, and the 14th Amendment's equal protection clause. So they give us the calls. Which is really, really nice. There are generally two types of con law essays. We saw this type for a very long time where they gave you the specific claims. Hold on one second. We also saw them like this, and then we started to see them like this, where they said, what challenges under the United States Constitution, if any, could so-and-so? They would say, like, basically, what constitutional claims can this person bring? So generally speaking, there's 2 types of con law questions. I really have a strong preference for this type where they give you the particular claims. However, you may see it like this, where you have to really run the gamut and say, and like rack your brain and say, like, is there any other big constitutional claim? So just like tip there. So be prepared for both types. And it was a trend for many years. For years, they pretty much did all of them like this. Then February 2018 came and they said, what constitutional claim? And then they did it again, and then they did it again like that. So be prepared to be done both ways. So you want to make sure that not only are you covering all of the topics within con law, but the different types of con law essays where they frame the question differently. You want to be prepared for that too. All right. So this one, so also your issue checklist here is really straightforward. What's your issue checklist? First, I still want to think about my big issue checklist, right? Preliminary issues, so standing. I know a lot of companies say that for every con law essay, you need to do standing, ripeness, and mootness. That used to be true, that they wanted ripeness and mootness, but they don't really care anymore. And we see that, we know that because a lot of selected answers don't include that anymore. And we see a lot of passing answers that don't include that. Would a perfect answer include ripeness and mootness? Yes. But if you are someone that is not trying to get a perfect score, and I hope that none of you are trying to get a perfect score, I wouldn't include ripeness and mootness unless it is in like at issue in the fact pattern. Like it looks like that it may not be ripe or it may be moot. So something like that. But so I see that they've laid these things out here. They laid these things out. By the way, this essay threw so many people off because they're like the 13th Amendment. They'd never seen that tested in an essay before. They love to do this. They love to do that. Where they're like, okay, well, we haven't done this in a really long time. Let's see what these people think. Hopefully you remember 13th Amendment against involuntary servitude. But you have here the preliminary issues, so standing. There also has to be state action. So I have that plus these specific things that they've called out, Let me give you all just a few minutes to read through the fact pattern, and I'll stop talking for a minute. All right, does anybody need more time? All right, now let's talk about this one. Let's talk about this a little bit. So after we look at this, here's just also some notes. And remember, I list some of the individual rights in here. These are some notes you'll get. So after step 2, we always think, okay, we always want to think of, even though they give us the calls, they give us a specific claims, preliminary issue, state action. If it was a broad call, you would just have these things. But here it should look like this. state action. And then I'm going to do, 1/13th amendment. 1 second, Michael. Due process clause and 3 equal protection clause. Yeah, Michael, what's up? Oh, do you not have a question? If you have a question, raise your hand again. All right.
It's hard to see the screen.
Oh, do you want me to make it bigger?
Yes, please.
Is that better?
Sure.
Can you all see that? Does anybody need it bigger? Yeah, sorry, I'm on like a huge screen. So which is why I don't realize that stuff. So thank you for telling me. I don't know what you mean with my view settings. Oh, are you saying tell the other person? Okay. But yeah, I'm always happy to like make stuff bigger, or I can like make the font a bigger size too. So, but let me know, y'all. Thank you for telling me. All right. So I jotted down my issue checklist. So I know I'm looking for this stuff. When they say due process, one note here, when they say due process, you have to think of both. You have to think of both substantive and procedural due process. You have to think about both substantive and procedural. Oh, Victor, I'm gonna have to look at that too, because I didn't know about that. All right, so now we're gonna go through and we're gonna read the fact pattern. And we're, taking note as we go along. And, generally you'd be marking this stuff up as well. You'd be taking notes on the fact pattern. So the legislature of state X recently completed a study on the behavior of teenagers residing in the state that revealed a connection between an increase in the school dropout rates and an increase in the level of criminal activity. Often when you see a fact pattern start off with the legislature of such and such state, then it tells you that you're in con law. That's often the case. Sometimes torts, but it's generally con law. And they'll often start with completing a study of some kind, because then they're going to use that to justify their behavior for whatever they're passing. So then that helps you identify, well, what is the interest? The study indicated that the connection was most pronounced among boys aged 15 to 18 years old. So I see two categories right there, right? And I know I have to think about equal protection. So I see they're going to be discriminating against boys, right? So there's gender discrimination, but it's boys that are 15 to 18 years old. So that's also age discrimination. One of those, so I think, okay, equal protection, those are different classifications. So they're discriminating on the basis of age, and they're discriminating on the basis of gender. So one of those is subject to intermediate scrutiny. One of those is subject to rational basis, right? Age is rational basis, gender is intermediate scrutiny. So I'm thinking, all right, so this is a classic equal protection fact. These are classic equal protection facts that where you're going to argue, where you're going to have, okay, one side's going to say like, no, one side's going to say this is gender discrimination, and then it's going to fail. The other side is going to say it's age discrimination, and it's going to pass, right? And you know who wants what. So troubled by what it perceived as a breakdown in personal responsibility and social order among its teenagers, State X's legislature has enacted a statute creating the State Forestry Corps, the Corps. The Corps drafts boys ages 15 to 18 who have dropped out of school. So they're drafting boys, right? So this applies only to boys, and it applies only boys who are 15 to 18. It sends them to camps located on public lands administered by the State Forest Service. This just is getting worse and worse. It also provides them with a comprehensive education leading to a high school diploma, right? So we're just saying, all right, we're going to take you. We don't want there to be a lot of crime, right? So the interest here is to reduce crime. That's important, right? And we also, I mean, like people getting a high school diploma is also a good thing, right? So you could say maybe there's also some education, but really it's to reduce crime. So when they send them away to work at these camps, they're also going to come out with a high school diploma. You can, think about the quality of it, but whatever, that's a whole other issue, not triggered by the facts. So to defray a portion of the cost, the Corps requires the boys to work on reforestation projects for a few hours each day. So there's your 13th Amendment, right? Involuntary servitude. Pete, age 15. So Pete qualifies. as belonging to this age group, and Pete, we can presume is a boy in this instance, we'll just, say that, has dropped out of school. So he's dropped out, so this applies to him. And consequently, so as a result, consequently, has been drafted into the Corps, And note here, Pete and his parents have filed a deck relief action attacking the validity of the statute under 3 provisions of the United States Constitution. So 13th Amendment's Involuntary Servitude Clause, 14th Amendment's Due Process Clause, and then the Equal Protection Clause. So we went through and read this. I want to then identify all of the issues here, and I want to list them. I'm going to put it in my fact pattern with the headings and the subheadings. So if I do this here, standing, and I want to point something out here. So this is what it would look like after this step, after I've read them, and I'm going to jot down all of the issues that are actually being tested. I'm going to do this. Okay. So standing, and remember, you could do standing, you could break it down and do it multiple different ways, but you could do standing for Pete, and you have to address standing for his parents. You have to address standing for his parents as well, because they both filed. So Pete has to have his own claims, and his parents are saying that they also have claims. It's not Pete's parents filing on Pete's behalf. Say that quickly. Right? It's not Pete's parents filing on his behalf. They're also filing. So they're saying that their own liberty interests have been infringed upon here. So you have to think about that. That's not part of the equal protection bit. That's not part of the equal protection, but that is actually part of procedural due process, fundamental rights. So there's a right to privacy. So standing, state action, then get into 13th Amendment. That you don't break down further, but I'm going to put my subheading. So they just said due process. So I have to think about procedural due process. So here, and I want to think about, well, what are these interests? So for Pete and his parents, Pete has personally lost his freedom. He's been drafted into the Corps and he's sent away to this camp, right? And then also his parents have a fundamental right. This is in the right to privacy and choosing how to raise their family. So they have lost that right as well. So you have to identify both liberty interests here. And I'm telling you all the issues that were tested here, but we're going to focus on actually like, how do you write the equal protection bit? And then after you established first for procedural due process, you have to establish that, life, liberty, or property has been lost. It's generally in the liberty interest. They also do test property interests. And then if you do that, then what is the process is due? There's like a 3-factor analysis there. And substantive due process, again, fundamental right, you establish that a fundamental right has been lost, and then you apply the standard. The way that fundamental rights are organized is really similar to equal protection, just by the way. And then I do equal protection. Now, this is generally what you have to think about with equal protection. Often what happens, or what you need to do is you have to say, okay, and this is the hard part. This is where so many people get tripped up with common law questions, is you have to come up with the classifications. This one is easier. This one is a little bit easier because it's boys and it gives you age. So it gives you gender and it gives you age. So you want to think of a classification. So classification, age. So you have to establish the classification, what it is, and then establish what standard it's subject to. So classification, age, then you get, and this is in one section where you're going to have, the rule, you're going to have an application and a conclusion, right? 3 little paragraphs here. So issue, right? IRAC, RAC. And then you're going to apply the standard. So you have your standard, or you have your heading, and then again, rule, analysis, conclusion. And then again, you're going to do this again because the other side is going to argue that it's gender. They're going to say that this is gender discrimination. Again, you're going to do RAC, and I'll walk you through this a little bit more in detail below and see. And then after that, you do, because there's these competing arguments, because it could be one classification or another, I then explain, what is the court more likely to hold between the two? You have to then have a discussion about, well, what is the classification here? What is the court, which classification is the court more likely to think that it is? Does anybody have any questions right now?
Maureen, can you please show the first page again?
Yeah. And you'll have this, you'll be able to see
Thank
this,
you.
but yeah. Yeah, I'll leave this up there for a second. All right. So we've read through the fact pattern, we've made our list, and we put in our headings and our subheadings. So now I've done my thinking, and I'm like, all right, I know what issues there are. I know what issues are here. I know what I have to analyze. I've thought, okay, well, what's the liberty interest for procedural due process? Which a lot of people don't know that's what you have to pull out from the fact pattern and identify as a heading. It's also like, when there's a lot of people in this particular essay missed that it was also his parents and that they have liberty interest. So then what you do is you go back and read through the fact pattern again and add the facts underneath the various headings. So I just did it here. I just added them here. I just added them in here. And this, I added them in here verbatim, but you could do it shorthand. You could just do, so classification age, you just say it only applies to boys 15 and 18 years old, and that's fine. So I add my facts, I added in my facts, and you do this, you do actually go in and do this. I added them in like literally verbatim, I pulled it out, but you could just pull out the verbatim facts. So I can say real connection and increase in rule. So yeah, we'll talk about what to do with this. So then I added my facts. I added in my facts, and now I'm going to go through, once I've done that for the whole essay, I'm going to go through and I'm going to start writing it. So, and it's at this point, once you've added in your facts, you should no longer have to look at the fact pattern at all. So you're just in your computer at this point, and you're like full on just in this one essay, just in this just at your computer. You're not looking off to the side and digging and doing all of that stuff. You're just in this fact pattern. That's when you actually start typing in your rules. That's when you start, well, actually, let me take a step back. After you've added in all the facts, you want to triage. You want to say, where are all of the facts? Where are there a lot of facts? Where is there controversy? Where do I need to make a counter argument, et cetera? And in the full course, we walk you through all of that. We walk you through, like in con law, I walk you through equal protection, due process, all of speech, all of that stuff. So we walk you through that stuff. I'm just picking, showing you a portion of this and what you guys can do. So triaging is identifying where the points are. It's a difficult thing to do, and it's something that takes a lot of practice, and it takes a lot of evaluation afterwards. One thing, whenever you are comparing what you wrote to an answer, you want to say, okay, how much in their analysis did they have, and how much analysis do I have? So you want to spend quite a bit of time here. Here on this particular essay, standing was easy, but there's a lot to get through because there's Pete and his parents. 13th Amendment was pretty straightforward. Procedural due process is a lot to get through for the liberty pieces, but it's pretty easy. But you have to talk about Pete and his parents. A lot of people miss this issue, but it's still pretty straightforward. I mean, I think most of this essay is actually pretty straightforward, but there's just actually a lot to get through. Yeah, Carla.
So you need to do two separate headings for the standing, one for Pete and the other one for his parents?
No, I mean, I don't think so. I wouldn't do that. The thing that I would actually probably do here is, and this was like me having an example here. If I have, like, in this particular essay, part of the triaging process is I'm like, there are so many big things for me to get through. I'm probably just going to have a rule, and then I'm going to say, oops, Pete here, Pete has suffered an injury because I'm going to do my analysis. There is causation. Oops. there is redressability. And then I would do Pete's parents. Pete's parents have suffered an injury because, and then I would say there is, oops, there is causation and redressability for the same reasons Pete has suffered. Explained in Pete. Thus, Pete and his parents standing. Because I know there's so much else I need to get through. I want to be really strategic about this. So I don't want to go and do like an individual breakdown of Pete and then an individual breakdown of his parents. I got to think about how can I do this most strategically. I probably wouldn't, like, this is an area being really strategic. This is because they didn't ask me directly about standing. In a perfect answer, would I break it down and go into all that, get all the rules? Absolutely. In a passing answer, did you have to do that? No. And I want to, like, when I'm teaching, I always want to show you how do you get to passing and like, how do you get to a 65? And then how do you go beyond that? That's what I want to show you. That's what I want to show you. So no, like in this instance, I wouldn't, because I've got to get through all of this is obvious. It's obvious to me that they have standing, like, and they didn't ask me about it directly. So because of that, I want to spend time on all of the unique issues and where there is things, where there are tougher things to analyze. They really want to see, do I know 13th Amendment? They want to see due process, both substantive and procedural. They want to know equal protection. And there's 2 classifications here, potentially. So that's what they want to see. That's what they
Thanks,
wanted.
Maureen. Thank you.
Yeah, for sure. It's a really good question. Yeah, so that's how I would do that. That's one of the things, like when you're triaging, that's step 6, that this is like, you're making decisions like this. You're making decisions like this. All right, let's talk about the equal protection bit. Let's talk about the equal protection. So at this stage, I'm going to actually put in my rules. At this stage, I'm going to put in my rules. So I put in, equal protection. I'm going to close the chat in this window. So here, I'm going to just make a note. Classifications based on age are not a protected class and are subject to rational basis review. And I want to use the facts in here. I often, like, not always in common law, so it doesn't work perfectly here, but I often have my facts typed in, and I usually just, like, if I had just put in my facts here, applies to boys aged 15 to 18, like, that's really all you need for this particular part. Here, the classification is based on age because it applies to boys aged 15 to 18. Given that this is an age classification, it is subject to rational basis review. So, and I pasted these facts just over and over because I'm going to decide what I'm going to use where. And then I'm going to apply rational, oops. I'm going to put these, I'm actually going to use a lot of these under rational basis. Oh, where did it just go? Oh no. Sorry, I meant to just do that. There we go. Couldn't figure what I did there. So under rational basis, a law is constitutional unless a challenger can prove the law is not rationally related to a legitimate government interest. So you're always, whenever you're applying a standard, you want to establish what the interest is first. It can be really tough to do this because you often have to come up with the interest. You have to come up with the interest. So the interest here, they gave us a study. They gave us a study where they talk about this behavior of teenagers and that there was an increase in the level of criminal activity. So I'm going to say here, the state has a legitimate government interest because, and I'm just going to use this fact, the legislature of state X has completed a study. They have a legitimate, and I'm going to use this other fact for the part of how it's rationally related. So I'm establishing that there is a legitimate government interest. And I might want to explain why is this legitimate? This is legitimate because why is this legitimate? Any government should be interested in reducing the level of preventable criminal activity. That's it, right? So there's two parts to this. So you always establish what is the interest, and then like my common law professor called it, how does it fit? Like you evaluating the fit of it. How is this the law fit into and how must it fit? So this just has to be rationally related to this legitimate government interest. That's a very low bar. It's a very low bar. So I usually do this in another paragraph. The law that state X passed, creating the Forestry Corps, the State Corps drafting, creating the State Forestry Corps drafting boys age 15 to 18 who have dropped out of school is rationally related to that interest in reducing crime, because the study indicated that the connection was most pronounced among boys age 15 to 18 years old. So that's why I type my facts in that process, because I'm going to just tie them in here. So when you type in your facts, you're actually typing quite a bit of your analysis. You're actually, yeah, thanks, Lucine. I see. Yeah, that's good. So based on this, right, rational basis, everything is pretty much going to pass. So thus, if the court construes, actually, one other thing I should have said at the beginning. I always forget this until this point. I do this every single time. Equal protection clause. So I give the rule here. I'm gonna say the court could view this legislation as classification based on age or gender, right? Age or gender. So like here, and then I get into the classification. Sorry, I should have said this, and I forget it every single time. Yeah, Carla.
Sorry, it's me again.
No, you're fine.
But when you analyze, when you do the rational, the analysis, don't you have to include that it is the plaintiffs who have to prove, have the burden of proof that the law is not rationally related to a legitimate government interest?
You do, and I do that usually in my conclusion, but you could say that here. Thus, and I that was actually the conclusion that I was writing right here.
Oh, okay, sorry.
No, you're good, that's my fault. So thus, if the court construes this as an age classification, Pete and his parents cannot prove this is unconstitutional, then they can't prove it, period. Then we want to do the same, then we want to do it for gender too, right? Gender has a little bit more specific of a test. So gender discrimination is shown when it facially discriminates on the basis of gender. Here it actually does do that. Or if the law is facially neutral, there is discriminatory impact and discriminatory intent. So first, the first thing I do, which is what I was doing above, and it basically looks like this. We're gonna do this. So, I don't like to divide them in numbers like that. I'm actually not gonna talk about the thing I was gonna say now. It's too confusing. Well, no, I am. So the first thing I did, right? So the first thing I did is I'm gonna say, what are the classifications? What are the potential classifications? I'm going to establish why that's one of the potential classifications. And you often have to come up with this. I'm gonna give you all a slightly tougher example in a minute. So identify the classification. So like I just did with age, then give the rule, identify or establish in your analysis that this is a classification, or that this is a classification based on what you said it is, like age. So do that and then apply the relevant standard, so rational basis. Then you want to look for, generally with equal protection, you're going to have to say, okay, well, it can be construed as this classification or that classification or that classification. So you have to present alternates. So then we're going to do the same thing. So here, this is classification based on gender because it only applies to boys. This is classification based on gender because it only applies to boys. The classification or the discrimination is facially discriminates because the core only drafts only boys. And only drafts boys who have dropped out. You could also say there's a classification based on high school dropouts. You could also say that, but that's also subject to rational basis. So you don't need to do that. You don't need to come up with a bunch that are on the same standard. The really obvious ones are age and gender. Only drafts boys. I'm not even gonna do all of that. So thus, the court may find that this is gender discrimination. And then I'm going to apply intermediate scrutiny, right? So what do we do first? What's the interest? There has to be an important government purpose, and it's gender discrimination. So it has to be an exceedingly persuasive justification. Here, and this lets me show another point. There is an important government interest in reducing crime. There is an important government interest in reducing crime. Do you guys think there's an exceedingly persuasive justification? Like, this makes me pause. I don't know. I don't think so. I'm going to say, however, there is likely not an exceedingly, usually to say that there's not a justification, you have to try to come up with, or usually to say that there is an exceedingly persuasive justification or something like that, you have to come up with an alternative, or you have to be able to like not come up with an alternative. So I'm going to say there's not an exceedingly persuasive justification because you could achieve this by, I don't know, you can achieve this by doing something else. I mean, what do they actually do? Don't they like, isn't there like a truancy? Isn't there like a truancy making it a crime? Do you have to like draft them and send them off to a camp? You know, can't you say that they can go to like doing, you know, they can give other alternative educational opportunities that aren't this. So likely not an exceedingly persuasive, and that's the challenge, is you have to come up with this stuff, but you just have to come up with something. I know it's hard, but that's also why you got to practice these essays, because it is hard, so you have to get used to doing it. There is likely not an exceedingly persuasive justification because the state can simply pass a law that requires, like I'm gonna say, you can at least that requires those who drop out of high school to complete an alternate path of study that you know, works for them. That does not remove the parents' right to parent their child in a way the parents see fit. Something like that. This is, remember, this is where you have to set forth an assumption, right? Assuming the court does find there is an exceedingly persuasive justification. The government must show the law is substantially related to that purpose. And here, the law, I don't know, I guess it is. The law may be substantially related, but likely. Oh yeah, Luciana, yes, that's true. But you have to, yeah, it is true. So it's gender. Can you discuss through male dropouts are more likely to commit the crime? State fails to cover what it does with female dropouts. Yeah, you could, but that's female. So like, that's why I think you have to focus on like, what is it doing? What is the remedy? So I'm getting at the remedy, which is the law. So yes, like, yes. But you have to say, so they're saying that the problem is that it's more applies to this particular group. So you have to say, do we need to do that? I think you can bring in what you're saying too, though. But we have to talk about the fit of this particular law, not the absence of what they're doing with other groups. Yeah, no, but really good. That's a good point. That may be substantially related, but likely fails because, and like here, Lucian, I think we can take what you said, likely fails because it fails to account for, what is it, like, what do they say? It's the other more, less pronounced. Connections and yeah, let's see, and doesn't deal with the root cause of the problem or something, I don't know. But you usually want to come up with an actual alternative. And the state can provide alternate flexible educational opportunities, something like that. Like you can do it through, like, I don't know, a lot of things. I'm trying to think of like what some family members I know have had to do when they've been in this situation. And then, so thus, given that this is, this could be construed as gender discrimination, the government can likely not carry its burden. Okay. And then we want to get to our conclusion. So then at the end of your equal protection section, and this took me, even though I know this essay, this took me 10 minutes to write out. That's another thing you want to pay attention to is how long does it take you to actually write out like your analysis when you're going through it? How long does that take you? Because that's part of the triaging process. If you have 40 minutes left, I have to do equal protection, I have to do all of due process, and I have to do the 13th Amendment. You don't want to spend all your time doing these crazy standing analyses when they didn't directly ask about it. So that's the other thing that you have to pay attention to when you're writing, when you're in practice mode. So equal protection conclusion, based on the, given that the statute expressly discriminates against based on gender, and then discriminates more based on age, because it goes boys 15 to 18, or vice versa, I don't know. Discriminates based on age in addition. And then discriminates on age as well. The court is likely to find that this is gender-based discrimination, and the and Pete and his parents will prevail on their equal protection claim. There you go. So I want to just walk you through how do you deal with equal protection. And that's what I wanted to show you all tonight. So just common law broadly, and then that's the most challenging thing, which is you have to come up with these interests. You have to You have to see how things could be classified different ways, and you have to deal with both of them. And then how do you do that step by step? Like, actually, how do you do that? There's stuff that I didn't go into. I generally talk about, like, I'll go in depth. Like in the class, I will go in depth and I give you formulas for writing analysis. I give you formulas for writing counter arguments. And in class, like, I will have all of you draft something and send me what you wrote. And I'll be like, yes, that's good. Yes, Lucine, that's great. No, tweak this part, or where's, you know, you need to use the specific facts. So we give you a lot of feedback in class too. Equal protection, it would be the various classifications. It would be your standards. Your buzzwords are for the rules. So like here, you know, it said it's not a protected class. It's subject to rational basis review. So rational basis, it's through the laws, rationally related is some of the buzzwords, legitimate government interest. So it varies. So it's throughout, each little section has their own buzzwords. So yeah, no, don't underline your buzzwords. No, it's poor form. All of this should be, yeah, Judy, that's a really good question. So let me first answer, should you underline them? No, it's like an insult to the grader and almost to yourself. It's like you're saying your essay should be so well organized that you know, like I know where everything ought to be. Like I know where everything ought to be and where I expect it to be. So underlying the buzzwords is like, that means that you probably didn't organize it well enough that the grader, that they can see it where they ought to see it. So it just tends to demonstrate some poor organization. But there's not there's not a right or wrong approach. There's really not a right or wrong approach. So if you initially argue that there was an exceedingly persuasive justification, then you would be doing the opposite, assuming the court does not find an exceedingly persuasive. Yeah, exactly, Judy, exactly. Yeah. So I hope this gave you guys a good sample of like what we do and some good tips and strategies for going forward. This is the last free workshop I'm doing. I've done a bunch the last couple of weeks. Just so you all know, we have a course, we go into all of this. We're covering, like, I'm doing common law. It's like a full 3 hour on like various common law essays. I walk you through like step by step, how do you get through free speech? What do you do? How do you lay out these arguments? A lot of people, like, nobody told me that I needed to do 2 classifications. And I didn't figure that out for the bar. I'm lucky that I didn't get a common law essay. So I like to really tell people this stuff. We like to lay it out. We like to show you, like, how do you analyze? We like to give you some feedback when you're in class. We give you issue checklists for every subject. We talk to you about, you know, outlining, and also, like, I don't do predictions. We don't do predictions because I loathe them. Yet at the end, I cover every single subject, and we talk about everything else. Oh, and we talk about what topics within each subject have not been tested recently. So I cover that. I do like an analysis of that for every bar, and you get to come to that. The big difference is, Yolanda, between the California essay and the MEE is that the MEE will ask more specific questions. Like, they're going to say, was this a violation of the 13th Amendment? They're going to get a lot more specific. Generally, the fact patterns are longer. California's tend to be shorter. The fact patterns are longer, and the questions are more pointed. But like here, if they said equal protection, if they said, is this a violation of the equal protection clause, you would do the same analysis. Judy, yes, it won't be posted as a Word document. It'll be posted as a PDF that you cannot download. Yes, this will be posted within about 2 days. Because we need time to process the video, and sometimes I do, like, you know, I start off with like food in my teeth, and Noelle has to edit the video, so it'll be posted though soon. Are there any other questions? No, Michael, they're left over from last time. No, not at all, Victor, not at all. And all of our workshop courses, like I have an essay workshop course, shocker, that starts next week, which is part of the reason I do this. We have a new MBE course. We have a new MBE workshop course with me, Mary Basic, and Tina Schindler. So if you guys know, have their books, if you have their books, you can, the 3 of us are teaching an MBE like workshop series. And we have a PT course that's really popular. And that starts on, for California, it starts next Monday. And for the UBE, if you're taking the UBE, it starts that Tuesday. So it starts, California starts June 6th and the UBE starts June 7th. Which is why I look tired, because I teach very late often. Are there any other questions? What's the real format of the exam if you registered with a laptop? Do you see? Yeah. So Anna, yes, you will get hard copies of the questions. If you're taking the bar on your laptop, you will not get them on the screen. You will get hard copies of everything, which is very important. Oh, sorry, that was my dog thinking that somebody was up there. Archie. There was a couple questions in the chat. Thank you. Thanks, Laura. Who is that on iPhone? I don't know who that is. Oh yeah, there's Archie. Hi. His eyes always look red on camera, but they're very blue and very sweet. Thank you so much, everybody. If you guys have any questions, please, feel free to reach out. If you plan to sign up for the course, let us know, just so we can make sure that we have enough space, and I don't need to have another section of it, which I don't anticipate, but if there's anything that anybody that needs, or anything at all, please definitely let us know. Thank you so much for coming tonight. I'm going to stick around. I'm going to turn off the recording, but I'll stick around and answer some questions if you all have any.